Welcome. This short video will introduce you to how to do your own direct data entry for the Immigration Court Observation Project. I'm going to introduce you to data entry. We use a survey tool called Qualtrics, and you will get the proper links and passwords for each type of form. When you log on to Qualtrics, you will see a form that looks like this, and you will provide the password that's been given to you, and then you will enter your forms. Some of you may get trained to enter your own forms, and some of you may get trained to enter forms for other people. You'll put in your name as the person doing the data entry, and then you will add the observer's name, and that might be you. Dates have to be formatted exactly the way it is written, 2 digits for the month, 2 digits for the date, and 4 digits for the year. I'm not going to fill in every question in this demonstration. I want to show you some of the pitfalls and some of the specifics. You, of course, will answer every question when you are doing it. When you do a shift time, you will enter the one that's closest to the time that you are actually going to court. It doesn't have to be exact. We are often looking at different dynamics that happen at the end of a shift versus the beginning of a shift, or the end of the day versus the beginning of the day, and that's why a rough estimate is helpful. Some of the questions are formatted where you can do multiple answers, and some are formatted that you can only do one. Leave blank in this case isn't very relevant, but the reason it's there is if you would inadvertently click something that you didn't want to click, it doesn't let you unclick it. Sometimes the only way to leave a question blank is to press leave blank, but in this case, I have an answer I want. For detained hearings and for the juvenile docket, we do try to collect a full A number. We have separated the entry of the first 6 digits from the last 3 digits because the last 3 digits are posted on the docket at the court and are easy to get right. And the first 6 digits are often wrong because judges mumble and it is hard to hear. So you will enter your digits without spaces or dashes. And then you will enter the last 3 digits there. There's a drop-down menu with most of the country codes listed, but not all of them. If it is not listed, you will click Other, and then you will list the country code. We ask, unless you are positive because you have the full list, we ask you to just enter the country and not try to Google the answer. In this particular instance, BO, we know because we have the ICE list, stands for Burkina Faso. If you were to Google it, you would come up with Bolivia. So please do not Google it. If it is not on the drop-down menu, just enter the 2-digit code. If you are interested in having the full list, I am happy to provide that. Gender is how the person appears or how they're being referred to. Don't belabor this point. We have a handful of transgender, non-binary respondents we have seen since the project began, and they have identified themselves that way, or the judge has talked about it in terms of an issue of safety. If a respondent doesn't appear, you would give the reason and check this box. Oftentimes it is that they are ill or that they have been transferred, that they have a competency concern, and so an attorney is speaking on their behalf. It does not happen very often. The judges also appear in a drop-down menu. And if you were to select Other, an open field would appear. That won't appear if you don't select Other. Government attorneys are all listed in the drop-down as far as we know. When somebody new comes, we add them at the bottom because if they were alphabetized by last name inserted, it would displace all the previous answers and we wouldn't get accurate data. So though they are alphabetized by last name, new people will appear on the bottom, or if their name changes, for instance, Summer Honeycutt had been Summer Spector Angsmiston, which is why she is alphabetized under S. So please read carefully before you select blank. These are the main ICE detention facilities. If it's something else that you know, you can click other and there'll be a place to write that. If you don't know or it's not stated, you can leave that blank. This question is asking what language the respondent speaks and understands the best. I'm going to show an example of this person speaks mom. The next question is, did they find an interpreter in the language the respondent speaks and understands the best? And yes, if they did, no, if they didn't. In this case, I'm going to say they didn't. And what language was provided to them? It was Spanish. And why am I not saying that here? Spanish, because we forgot it initially and it's at the bottom. I also want to say that if somebody speaks English, the answer is always yes. They speak English, they were given English because that's the language all the judges speak. It's not a problem. Any question about any problem with interpretation, you just check, and you can check more than one in this section. Sometimes you can only select one answer. If you have any comment to make, you can make it here. In terms of bond, there should be only one answer. They did not ask for bond. They asked for bond and there was a bond hearing today. They asked for bond and there wasn't a bond hearing today. I'm not going to discuss much about these other things, but sometimes there's not a bond hearing held today, but the judge will say something to them about the need for evidence, and without evidence, she would deny it. You can add those comments wherever it seems most likely appropriate, even though that specific question is not asked. If a bond hearing is held, you want to answer all the bond questions, even if the answer is left blank, leave blank. For instance, not for instance, I did want to say that we want you to listen very carefully to whether the judge says they have no jurisdiction, whether bond is actually denied, or whether the judge makes some other comment about the bond decision. Some of the reasons it could be denied are because they have no jurisdiction or because somebody is subject to mandatory detention. We also want you to write anything else the judge is saying. For instance, if you hear something about the matter of MS or the matter of Q. Lee, there's very specific statutory reasons why sometimes the judge has no jurisdiction or somebody is subject to mandatory detention. You don't need to understand those things in order to write the answer about what you hear. Only if the judge makes a bond decision of granting or denying is there a reason for either party to appeal. So if there's not a final decision because the judge is going to issue a written decision, then you just leave that blank. Often the judge won't ask if somebody wishes to reserve appeal. She will just give an appeal date, in which case you would write, judge didn't ask. The question, how did the respondent get into ICE custody? Often it is not discussed. It does not mean why are they in removal proceedings. It's asking why are they being detained as opposed to being out of detention. If there's a comment, you will write it in. Pleadings is very confusing, and if you aren't 100% sure how to know when it's pleadings or not, please ask for more instructions, which we have written, and you can also read the overview of proceedings in the volunteer manual. If pleadings are done, you want to answer these other questions. Most often it's concede everything in the NTA, but it is not always. And often a respondent will decline to designate a country because if they're asylum seekers, they specifically don't want to be sent back where they came from, although that's the country that the government will designate. If the judge does pleadings, they 99.9% of the time will screen for relief immediately after, because if a person has admitted that they are in fact deportable because they're here in violation of immigration law, the judge is going to see if they have any possible legal basis to stay. And if they do not, the judge is going to immediately order a deportation, and there is no need to detain anybody any longer. So in this case, I'm going to say yes, they did screening, they're eligible to apply. That might be because they've lived here a really long time and can apply for cancellation of removal, or it could be because they have a fear of return and they're going to apply for asylum. Pick any of these that seem relevant, and you may click more than one. Any other comment about questions asked or answered or instructions about relief may be put in this box. Often there are issues of eligibility only for an application that can be adjudicated before USCIS, and that's a problem because the judge needs an application that's submitted before the court in order to continue proceedings. If there's any particular mention of forms of relief, you want to fill this out. This may even happen in the context of a bond hearing, where maybe an attorney will say, my client intends to apply for asylum. So you can answer this question even if pleadings weren't done and screening wasn't done. Sometimes this will come up. If they talk about an I-589 application and they don't specify any particular form of relief, you just press I-589 not specified. If they mention asylum, withholding, or CAT, you would fill those out. CAT is sometimes also referred to as DCAT, or deferral of removal, because the official word title is deferral or withholding of removal under the Conventions Against Torture. If you aren't sure, it's fine to always write not specified. Again, you can answer multiple questions under this. And for instance, I'm going to demonstrate that here. Did the judge explain evidentiary rights? Some examples are written on here. Don't ever feel bad about checking no, no, no. It does not mean that the judge is doing a bad job. Sometimes some things are done at one hearing and other things are done at another, and yet other things are done at another. Most people have 2 to 5 master calendar hearings during the course of proceedings. Did the judge explain that all applications and evidence must be in English and to save a copy for themselves? We have expanded on this question in Qualtrics, and that's not actually on the form. But you can say yes, but you can also specify exactly what they said, because often they do a part of it. Often they say everything must be in English, and they may say save a copy for yourself, but they don't often explain how to get it to the court and how the jail can provide information, or about submitting documents that are in another language translated into English with also the original and what a certificate of translation means. And often they say, if they do say anything, certified translation, and people think they need to hire somebody with a particular credential as opposed to just somebody has to attest that they're bilingual. Did the judge give a filing deadline? And you can use this for an application or evidence. But if it is for an application or it's for evidence only, because usually the application is due first, you want to put that comment in section 28. So here I'm going to write an answer, 07/14/2025, and this is application due. Did the respondent ask to be deported? Sometimes we see this because they're sick of being in jail. Sometimes people will ask to be deported because they are denied bond and they don't want to stay in jail for the duration of their hearing. This doesn't mean it's going to happen. Sometimes people ask for deportation and then ultimately change their mind because the judge convinces them to apply for relief. Do not confuse this with voluntary departure. Voluntary departure is a form of relief where they leave the country without a deportation on their record, provided they have a travel document, usually a passport, and the means to pay for their own ticket. Although just requesting it doesn't mean they get it. But the main message here is if they say, send me back, I don't want to be in jail anymore, I give up, I don't want to file for relief, I need to go home because my grandmother is dying, or any such reason, that is, yes, they ask to be deported. I'm going to say I'm sick of being in jail. If the government made any arguments, made any comments, it could just be they affirm that they've submitted uploaded files, or they could be making a strong argument against why somebody doesn't have a good basis for relief. Whatever they say, you can put that there. I'm going to say they didn't speak because that's really common. I want to make one other comment, which is that even if it's a bond-only hearing, we still want you to answer every question in the removal hearing section, because many of these things can come up in a bond hearing. And the only way we know that you didn't forget to enter something that happened is if you answer every question. So the only questions that should ever be left blank are the bond questions if nobody asked for bond and bond wasn't discussed. Otherwise, please answer every single question. So in this case, I did say the person asked for deportation, but I'm going to say the case was continued if that indeed happened. And I'm going to put the date of the next hearing. And then we know it's at AM. This question is only if the judge actually ordered somebody deported. So I'm going to say not applicable because the person wasn't deported. If somebody does get a removal order, you can answer, and I'm going to just change this now to show you an example. You can say the judge did give advisals, but then just like an earlier question, these examples are not on the form because there isn't space, but they've been added here. So sometimes the judge will just say, talk to the deportation officer. Sometimes they'll explain you're barred from reentry for 10 years. You can be fined for non-cooperation, and you will be barred from certain forms of relief for the next 10 years. There are even more details that can be explained, but typically all we're hearing is this, and that's a problem. So I'm just demonstrating that as an answer. If the judge made a final decision, which means I'm granting you voluntary departure, I'm granting you relief, or I'm doing a removal order, either party can appeal. And so she would be asking for that appeal decision. If she doesn't ask whether they reserve appeal or waive appeal, then you can mark judge didn't ask. Again, sometimes all the judge will say is if you wish to appeal, this is your deadline. Of course, if somebody formally waives appeal and they have a deportation order, it's going to speed the deportation along. So the judge should be asking. Criminal history, we really actually only want one answer on this. So if they have one arrest, but you don't know if it was a conviction, you'd mark arrest. If you know they've had at least one conviction, then you'd actually mark has at least one conviction. And then any comment about the criminal history. It doesn't have to be in great length, but we'd certainly want to know about convictions and what they were for. If you know, and roughly the time period when they happened, we are seeing people arrested and put in detention for crimes that happened 25 years ago. This didn't used to happen, so that's relevant. But if there's 4 DUIs, we don't need the dates of all of them. You can say 4 DUIs, 3 convictions, 1 pending, high blood alcohol content, that's plenty. For time in the United States, we prefer years. So if they've been here 1 year, 6 months, you write 1.5 years. And you don't write words, you just want to enter it with a simple decimal point. But we only want boxes in one, so we don't want you to write 1 year, 6 months. We would prefer you to write 1.5. If 1 year, 8 months, you can write 1.75. It doesn't have to be exact, it's approximate. We're really trying to get find out how many people have been here 10 years and more, and how many people are recent arrivals. If you know that somebody recently crossed the border, or you suspect that based on the conversation, you can put an X here. If you have no idea how long they've been in the country, you would just put an X here. If you know something, you can say entered July 2025, crossed illegally. I can't spell, but you can get the point. Illegally with mom. Do they have family in the United States? Again, I'm leaving some questions blank just to speed it along. You want to answer every question. If there are people in court, sometimes you can't tell. If they acknowledge who's in court for you, I'm going to show you on the camera, and they can say, that's my pastor or that's my boss, then supporters were acknowledged. Any concern about well-being, and I'm going to say asthma isn't getting inhaler. We do not want you to second guess anything. So we want really obvious things. You don't have to say, I couldn't see the screen, so I couldn't tell. We're obviously really concerned about mental health and any untreated physical illness, but please don't surmise that somebody's chemically dependent because they have DUIs. We're not qualified to do that. So these are things stated on the record or things you see with your own eyes that are concerned. You can't see, you don't know, nothing suspicious. There's absolutely nothing wrong with saying no. Complaints about conditions in detention, yes or none stated. Add them below. Any additional comments that you have, you would add here. Again, we really suggest that you go back and you review everything you put in to make sure that you haven't made a mistake before you enter it. So you would, I'm not going to do it now, but you would scroll all the way to the beginning and make sure that there's nothing you want to add. Sometimes you'll be looking at your notes and you'll realize that something you were going to add at the very end really is a question that is asked earlier in the form. It is much preferred that you put the information where it goes. So we don't really want to know, under the impression, says a mother and a father in this country has been in the country 7 years. We really want that in the place where it is asked, because that's where we will go looking for it. And we have a lot of data, and data analysis is important. But if we have to hunt through every box to find what we're looking for, it's going to be very difficult for us. So when you are sure that you've done it right, you are going to just click the button and you should get a thank you for doing it. Now, if you have another form to do right away, you can go right up to this web link and click it again, and it should take you right back to it. And you can enter the password again and start your second form. I hope that's given a good explanation. The forms are slightly different for other types of hearings, but you follow the same principle of using the link. It's always the same password. It's going to ask who's entering the form. You're going to review it before you right-click to submit it. And please, if it requires specific information from you or a specific format, please read it carefully. The Qualtrics forms are designed to help you understand what's being asked and the format the answer needs to go in. Remember that there's a combination of drop-down menus and fill in the blanks and multiple choice, and that it doesn't exactly mirror what's on the form because Qualtrics does not let you have a checkbox and a blank in the same question. So many things in Qualtrics, a question from the form will be separated into 2 or 3 questions, but hopefully this demonstration has made that obvious. Thank you for doing data entry because it really helps us be more efficient in getting forms entered, and I am happy to answer any questions you might have at any point. Thank you.